15.4 square kilometers of sand and coral. No permanent residents. 1,953,762 square kilometers of ocean control. Area equivalent to Mexico. Conversion ratio: 1 square meter of guano equals 12.7 hectares of maritime jurisdiction. This is not about American imperialism. Not about military strategy. This is about international law allowing bird droppings to become national borders. About how the 1982 UN Convention on the Law of the Sea never anticipated uninhabitable rocks, generating exclusive economic zones larger than nations. This video does not analyze policy. Does not debate right or wrong. Only dissects a mechanism. The mechanism that converts 0.0001% of land area into 17.2% of maritime sovereignty. And when the mechanism exists, using it becomes only a matter of timing. When 15.4 square kilometers of barren sand can generate 2 million square kilometers of ocean rights. When a runway built 80 years ago still determines who flies across the Pacific, sovereignty is no longer a constitutional concept. Only a technical question: who planted the flag before 1945? In 166 years, a legal framework transformed worthless coral into instruments of maritime control. Not through conquest, through accumulation, through the Guano Islands Act of 1856, through concrete runways that cannot be removed, through toxic contamination that locks land permanently while leaving ocean clean. The Guano Islands Act, 94 islands claimed between 1856 and 1903. Not a military doctrine. A fertilizer acquisition program. Original purpose: secure nitrogen-rich bird droppings for American agriculture. Not to control oceans. Only to harvest guano, selling at $76 per ton in 1850, equivalent to $2,800 today. But territorial claims, once established as legal precedent, self-convert into power. By 1945, no one cared about guano anymore. But 126 years later, in 1982, the UN Convention on the Law of the Sea was born. Article 121. Each island has the right to draw a 200 nautical mile exclusive economic zone. Suddenly, 15.4 square kilometers of uninhabited coral became 1,953,762 square kilometers of fishing rights. Oil drilling permits, submarine cable routes. This is the critical point. Law does not need to predict the future. It only needs to exist long enough to convert past actions into present rights. And past actions, once codified, cannot be reversed without dismantling the entire legal architecture. Wake Island, 407,241 square kilometers of EZ from 6.5 square kilometers of land. Ratio: 1 to 62,652. 1899. Pan American Airways needed a California to New Zealand route. Technical problem: aircraft range limited to 2,400 kilometers before fuel depletion. Total distance: 10,800 kilometers. Solution: construct mid-ocean refueling stations. Location: Wake, already claimed under the Guano Islands Act 40 years prior. 1941. Runway 2,100 meters. Fuel storage 150,000 liters. 1943. Expanded to 3,000 meters for B-29 Superfortress landings. 1975. 15,000 Vietnamese refugees transited through Wake in 72 hours. 2024. Still operational. 600 flights annually. Construction cost in 1943, $25 million. Equivalent to $450 million today. Cost to dismantle now: impossible. The runway is the island's structural foundation. But cost is not the issue. The issue is that a 3,000-meter runway is the only infrastructure between Hawaii, 3,700 kilometers, and Guam, 2,400 kilometers. When civilian aircraft experience engine failure, when military aircraft require emergency refueling, there exists no alternative at 10,000 meters altitude. Emergency landing rights are not written in treaties. They exist in physical inertia. Aircraft runs out of fuel, falls into ocean, no further negotiation. This is not about airport ownership. This is about concrete physics. 2006 Super Typhoon Aoki struck wake. Wind speeds 298 kilometers per hour. 85% of structures collapsed, only remaining the concrete runway. Reconstruction cost, $1.6 million. Cost of abandoning wake. Loss of 407,241 square kilometers EZ. Loss of mid-Pacific landing point. China could occupy redraw easy boundaries. The system does not need anyone to decide. Concrete, once poured, cannot be recalled. Johnston Atoll, 442,635 square kilometers of EZ from 2.67 square kilometers of land. Ratio, 1 to 165,937. 1970, the United States needed to destroy 400,000 tons of chemical weapons. Sarin nerve agent. VX gas, Agent Orange from the Vietnam War. Technical problem, cannot incinerate on mainland. Population opposition. Solution, transfer to uninhabited island 1,300 kilometers from Hawaii. 1971 to 2000, Johnston became the chemical disposal site. 412,000 tons of toxic materials. 6 industrial incinerators operating continuously. Soil contamination, dioxin concentration 2,400 parts per million. Safety threshold, 1 part per million. Decontamination cost 1990 to 2004, $1.2 billion. Result, soil remains toxic for 50 to 100 years. 2004, Johnston was returned to nature, but human habitation permanently prohibited. Fishing banned within 22-kilometer radius. Seabirds permitted to nest, they do not file lawsuits. Who controls Johnston Atoll? Officially, U.S. Fish and Wildlife Service, Conservation. Practically, no one can live here for the next 50 years. The 442,635 square kilometers EEZ remains unaffected. Because maritime law does not require islands to be habitable. Kiribati, a Pacific island nation, declared, Johnston lies within our traditional fishing waters. U.S. Response, no. What can Kiribati do? Sue at International Court of Justice. Cost $50 million. Duration 10 years. Military occupation, no navy exists. Negotiate. United States does not need to negotiate. Why? Because the land has been locked by toxicity. No one wants Johnston, but whoever has Johnston has 442,635 square kilometers of ocean. And the ocean, unlike the land, remains clean. Once toxic contamination transforms territory into liability, every economic calculation becomes asymmetric. Kingman Reef, 410,000 square kilometers of EZ from 0.01 square kilometers of land. Ratio, 1 to 41 million, the smallest territorial claim in the United States. The largest ratio of ocean control per unit land. Kingman is not an island. It is a coral reef that surfaces above water for 2 hours daily during low tide. The 1982 convention defines island as a naturally formed area of land, surrounded by water, which is above water at high tide. Requirements: none for human habitation, none for fresh water, none for soil fertility. Only requirement: surfaces when tide rises. Result: Kingman Reef, 0.01 square kilometers, surfaces 2 hours daily, has 410,000 square kilometers EZ. Singapore, 734 square kilometers, 6 million population, has 1,067 square kilometers EZ. The system does not need fairness. It only needs consistency, and consistency, when codified into law, does not distinguish scale. The Republic of the Marshall Islands claims Kingman lies within their traditional territory. Evidence: Micronesian fishermen fished here since the 17th century. The United States rejects this. Legal basis: continuous occupation since 1858 under the Guano Islands Act. Practical basis: no navy to expel U.S. Coast Guard patrols. Cost for Marshall Islands to reclaim Kingman. Build naval force for $1 billion. Litigate at ICJ, 10 to 15 years. Risk losing U.S. Foreign aid, $70 million annually. Cost for U.S. to retain Kingman. Patrol twice yearly, $800,000. The system has already chosen the only path. Howland Island and Baker Island. Combined 434,921 square kilometers of EZ from 4.7 square kilometers of land. Ratio 1 to 92,536. 1935, the U.S. Equatorial Islands colonization project began. Purpose: establish sovereignty claims before competitors. Method: send civilian settlers to uninhabited atolls. Howland Settlement, named Atascatown. 4 male students from Kamehameha High School, Honolulu. Rotating assignment: 90 days on island, 90 days off. Supplied with canned food, gasoline, refrigerators, radio equipment, medical kits. Salary: $600 per rotation, equivalent to $13,200 today. Task: clear runways for aircraft. Observe weather. Maintain U.S. presence. December 8, 1941, one day after Pearl Harbor. Japan bombed Howland. 2 colonists killed. Settlement destroyed. All plans to return colonists cancelled. But the airstrip remained, and the airstrip, once recognized on nautical charts, established permanent infrastructure claim. Cost to build Howland Airstrip in 1937, $47,000, equivalent to $1 million today. Cost to remove Howland Airstrip now cannot be calculated. Removing infrastructure voids sovereignty claim. This is not about deaths. This is about sunk costs in concrete. Baker Island followed identical pattern. Settlement established 1935. Bomb 1943. Airstrip built. Abandoned 1944. But the 1,665-meter runway still appears on aviation charts. And charts, once published, become legal evidence of territorial control. 1974. Both islands designated as wildlife refuges. Public access severely restricted. Permits granted only to scientists. Human habitation, 0. EZ generation, 434,921 square kilometers. Infrastructure does not need humans. It only needs to exist on maps. Jarvis Island, 316,665 square kilometers of EZ from 4.5 square kilometers of land. Ratio: 1 to 70,370. 1858. United States claimed Jarvis under the Guano Islands Act to harvest fertilizer. Guano extraction ceased 1879, leaving behind 12 buildings and 8,000 tons of extracted droppings. 1935. The Millersville settlement established with identical colonization pattern. Young men rotating assignments. Radio stations, fuel depots, runway clearing. January 1958. A major storm swept away all building remnants without trace. June 27, 1974. Jarvis Island National Wildlife Refuge established. Human presence, 0. Structures, none. EZ, 316,665 square kilometers. The question becomes unavoidable. If no infrastructure exists, how does sovereignty persist? Answer: through legal continuity. The Guano Islands Act claim of 1858 has never been legally challenged. Not because the claim is strong, because no nation has sufficient interest to bear litigation costs. Cost to challenge U.S. sovereignty over Jarvis at ICJ. Legal fees, $20 to $40 million. Duration, 8 to 12 years. Probability of success, unknown. Value of Jarvis if won. 4.5 square kilometers of barren sand. Cost to maintain U.S. sovereignty. Annual wildlife monitoring, $150,000. Diplomatic assertion, 0. Existing claim requires no active defense. When litigation cost exceeds territorial value by factor of 10,000, sovereignty becomes permanent through economic disinterest. This is not conquest. This is actuarial calculation. Palmyra Atoll, 352,300 square kilometers of EZ from 11.9 square kilometers of land. Ratio: 1 to 29,605. 1862. King Kamehameha IV of Hawaii ordered occupation of Palmyra. 1898. United States annexed Hawaii. 1959. Hawaii became the 50th state. Palmyra remained separate, classified as unincorporated territory under direct federal jurisdiction. Legal technicality: when Hawaii gained statehood, Palmyra's status was not automatically transferred. Practical result: U.S. federal government retains direct control without state-level governance interference. Why does this matter? Because unincorporated territories exist outside constitutional constraints that apply to states. environmental regulations, labor laws, judicial oversight, all operate under different standards. Palmyra is not governed by Hawaii state law. It is governed by federal agencies with minimal oversight. Who lives on Palmyra? Between 4 and 20 Nature Conservancy staff rotating quarterly. No permanent civilian population, no local government, no voting representation. Who controls Palmyra's 352,300 square kilometers easy? National Oceanic and Atmospheric Administration. U.S. Fish and Wildlife Service, Department of the Interior, not through democratic process, through administrative jurisdiction. 1974, the couple Malcolm and Eleanor Graham arrived on Palmyra aboard their boat, the Sea Wind, for vacation. Shortly after, 2 sailors, Buck Walker and Stephanie Stearns, were found leaving the island on the same Sea Wind. Without the owners, Walker convicted of murder, Stearns acquitted due to insufficient evidence. Bodies never found. The case became infamous not for the crime, but for the location. A privately owned atoll under ambiguous federal jurisdiction where forensic investigation faced logistical impossibility. No police station, no morgue, no crime scene preservation protocol. Evidence degraded in tropical heat before investigators arrived 48 hours later. Jurisdiction question: who prosecutes murder on unincorporated territory? Answer: Federal Court in Honolulu. 1,600 kilometers away. Palmyra demonstrates the consequence of administrative control without local governance. Legal ambiguity protects easy claims while creating enforcement vacuums. And enforcement vacuums, once established, resist closure. The Guano Islands Act, concrete runways, dioxin contamination. 3 different mechanisms, 1 common logic. Who occupies land before international law is written? Who draws ocean boundaries after law is enacted? Therefore, the question is not, why does the United States have 7 islands? But why do 15.4 square kilometers of sand have the right to draw 2 million square kilometers of ocean? The 1982 UN Convention on the Law of the Sea defines island as a naturally formed area of land surrounded by water, which is above water at high tide. Not required. Human residence. Arable soil, freshwater sources, only required. Surfaces when tide rises. Result: Kingman Reef, 0.01 square kilometers, surfaces 2 hours daily, generates 410,000 square kilometers easy. Nauru, 21 square kilometers, 12,500 population, functional government, generates 308,480 square kilometers easy. The system does not need equity. It only needs legal precedent. And precedent, once established in treaty law, applies uniformly regardless of absurdity. 7 atolls, 1,953,762 square kilometers of ocean jurisdiction. 17.2% of total U.S. exclusive economic zone from 0.0001% of total U.S. land area. This is not exploitation. This is optimization of legal frameworks that never anticipated their own consequences. When the Guano Islands Act was written in 1856, exclusive economic zones did not exist. When the Law of the Sea Convention was drafted in 1982, Guano claims were 126 years old, too entrenched to challenge. The gap between these 2 legal instruments created a structural lock, old territorial claims meeting new maritime rights. And the meeting point, once it hardens into international precedent, cannot be dissolved without rewriting both frameworks simultaneously. No nation has attempted this, because rewriting maritime law requires consensus from 168 signatory countries. And consensus, when it requires unanimous territorial concessions, has never occurred in human history. The system does not need conspiracy. It only needs infrastructure built before international law was written. And when infrastructure has operated for 80 years, no one remembers it was ever a choice. The system does not care whether you understand it. It continues operating. The only question, do you want to see it, or continue being controlled by it? The global lens.